Well, good morning, everyone, or good afternoon if you're connecting from Europe or elsewhere. And welcome to today's webinar, the UN Cybercrime Treaty. Is it a crime? I am Michael Todori, the president of the Washington Foreign Law Society. WFLS was founded in 1952 to promote knowledge and understanding of international and comparative legal issues and foreign law. And it's a nonprofit organization based in DC, serving as a forum for discussion among legal and non-legal professionals serving in public and private capacities within a diverse range of organizations, including international organizations, law firms, US government, foreign missions, NGOs, academic institutions, and private sector companies. Today's event is organized with the support of the Stimson Center, the Harvard Kennedy School's Carr Center for Human Rights Policy, and the DC chapter of the Alumni Association of Lewis University. And thank you to all of our co-sponsors for today's panel. And today's event will be moderated by Allison Pitlack. Allison is program lead of the cyber program at the Stimson Center and has researched, written, and published extensively in the fields of cybersecurity and diplomacy, particularly in the gendered and human rights-based dimensions. So a couple of quick housekeeping notes before I let Allison introduce our panelists. You'll see a Q&A feature at the bottom of your screen. You can use that to send in questions, and I know some of you have already submitted questions before the event, so we'll try to get to those at the end of the session. As you've heard at the beginning, the session is being recorded, and prior recordings of all of our WFLS events are available on our website, and I'll post a link to the website. We also have a revamped website, so be sure to take a look. And finally, don't forget to follow us on Twitter. Handle is @WFLS1952 and LinkedIn. And one final note, if I may, please consider becoming members of the society. There's a discounted rate for students, government, and nonprofit employees, and I'll be putting the link in the chat. And with that being said, Allison, the floor is yours.
Great. Thank you, Michael, and thanks to all of our other co-sponsors on this event today. And of course, a big thank you to our panelists and to our audience for tuning in. I'm very excited about today's topic, and I think it's a great one for this webinar series. While we at the Stimson Center have not been participating very closely in the treaty process, we have been investigating and researching cyber accountability. And so from that perspective, the negotiation of new international binding law is undeniably significant. And the content of that law, of course, will influence and need to intersect with cybercrime law at national and regional levels. But getting to agreement is not easy, and there are different opinions and views and positions on some core aspects of the draft treaty. And this is what we're going to hear more about today from our two expert panelists. But before turning to them, however, and just by way of introduction, I thought it could be useful to offer some simple background on the UN Cybercrime Treaty process, just to make sure we're all starting from the same place here. So going back to December of 2019, the UN General Assembly passed a resolution that established an open-ended ad hoc committee, or AHC, which is an acronym that you will hear often in this next hour, that was tasked with developing a comprehensive international convention on countering the use of ICTs, information communications technologies, for criminal purposes. This is Resolution 74247. And because we will talk more about human rights later on in the hour, I do think it's worth noting that this resolution, which kicked off and mandated the treaty process, began in the General Assembly's third committee, which is the committee that is dedicated to human rights. Some of the other UN forums you may have heard of, like the open-ended working groups, the groups of governmental experts, they come from other parts of the GA committees, other committees, but this one has its roots and its origins firmly within a human rights-oriented body. Negotiations began in early 2022, following an organizational session the prior year. There have been, I think, 6 negotiating sessions, 3 in Vienna, 3 in New York, as well as several intersessional meetings. The process is being chaired by Ambassador Mabarki of Algeria, and the secretariat for the treaty is the UN Office on Drugs and Crime, the UNODC. And so after all of these intersessionals and formal sessions, a draft treaty was released earlier this summer in June, I believe. And this was the focus of the most recent AHC session that was held in August of 2023. And I have to say, I've been part of a few treaty talks. This is looking like a very long treaty. It's many, many chapters, many, many articles. So I think there's a lot going on and a lot to talk about today. And this is exactly what we're going to do. What happened in August? What is in the draft treaty? And what are some of the major concerns or stumbling blocks? There is only one more planned or mandated session on the schedule at the start of 2024. So what are the prospects for getting to agreement? And because no negotiation takes place in a political vacuum, there are also some powerful geopolitics at play here, which I anticipate our speakers will help to unravel further. So I'll start by introducing our panelists now. Dr. Nana Ifeanyi-Ejiofor is a professor of law at the School of Law at the University of Bradford, but she's also a technology and human rights fellow at the Carr Center for Human Rights Policy at Harvard University, one of our co-sponsors today, and serves as the vice chairperson of the African Union Cybersecurity Experts Group, where she has been advising the AU Commission and African member states on legal frameworks related to cybersecurity and has represented them in the treaty negotiations. And I believe she'll be speaking largely from that perspective today. And we're also joined by Joyce Hakme, who is a policy expert in international security, focusing on cyber policy. She is the Deputy Director of the International Security Program at Chatham House and the co-editor of the Journal of Cyber Policy. And in her role, Joyce oversees the research agenda of the program and leads the work of Chatham House on cyber policy issues. Welcome to both of you, and thank you for taking time to join us today. Joyce, I think I might start with you and put my first question out there. So Chatham House has been such a rich source of information about the cybercrime treaty process, from briefings to explainers, an interview with the chair of the process. You really helped a lot of different audiences understand what is happening in the room. And so from that vantage point, can you tell us more about where we are right now? What happened in August?
Thank you for the introduction, Alison, and I'm delighted to be here today with you and Nana to discuss the recent developments in the AHC process that is, developing a cybercrime convention. So what happened in August and where are we now? Maybe to kind of continue the backstory that you started, you mentioned the modalities of the process, and according to the modalities, there should be, as you mentioned, at least 6 negotiating sessions of 10 days each. The August session was session number 5, the penultimate session. It was a very important one because after months of negotiation, states were for the first time negotiating a draft text of the convention. But where did this draft come from? There have been some big efforts that led up to that moment. So in the previous 4 negotiating sessions, states discussed for many, many hours their approaches and proposals for the different chapters of the convention. What do they consider as cybercrime? What powers should law enforcement have to be able to prosecute cybercrime? How should states cooperate? When they should not cooperate? What safeguards should be in place in order to avoid abuse and misuse, and so on and so forth. And in so doing, they would sometimes agree and sometimes disagree, as you would expect from, any negotiation. So after those sessions, and then maybe sort of throughout these sessions, it became clear what the key positions are, right? And what the points of divergence and convergence are. So based on all of this, and as you mentioned, the chair developed the zero draft, although she likes to refer to it as the draft text of the convention, and published it before the session began. Now, there were all these contradictory proposals, right? Like, and different approaches to the same issues. So the chair had to find a way to proceed. She had to sort of find a way that, illustrates the common ground that states could agree upon. So what she did in that zero draft, she included the proposals that enjoyed broad support in the first 4 sessions, and she excluded the ones that did not. I mean, that's largely speaking, of course. So in a way, way, this draft sort of illustrated her vision of what a common ground is, and based on what states have said. So she was quite adamant to say, this is not my draft, this is your draft. And she also included there some compromise solutions for the issues of divergence. Now, the hope from doing this exercise was that states would accept her approach and not go back to their initial positions that did not garner consensus. And so the needle can be moved forward in the process, and the remaining time would be used then to finesse the draft and negotiate the remaining areas of this agreement. However, that's not what happened during session 5. Several states who did not get what they wanted in the convention pushed back against the chair's approach and reintroduced, despite her wishes not to do so, their initial proposals. And so at the end of session 5, you went from having a draft convention of 40 pages to one, of 37 pages, I think, to one that was like 77 pages. So you had 40 extra pages that were added to the draft. So that basically meant that instead of narrowing down the areas of the divergence and organically arrive to the concluding session with some clear options, what ended up happening is that almost all original proposals were put back on the table, right? And there were new ones that were added as well that weren't negotiated before. So instead of moving the discussion forward, in a way, sort of like moved backward to pretty much where we were a few months ago, even like a year ago. And as you mentioned, Alison, there's one more session left, so which means, you know, getting to that place is quite a tricky situation because now the uncertainty really increased and there isn't a clear scenario on what the outcome of the final session will be. Maybe worth noting before I conclude is that there are sort of like some steps that will happen between now and the January session that are worth noting. So the chair formed around, I think, 8 informal groups chaired by different countries that were negotiating in parallel to the actual sessions. And these groups were sort of thematically formed, and they were meant to sort of bring the different points of views closer and then feed back into the plenaries to kind of, you know, make the most of the time that is allocated. So these groups have made some progress, albeit like, you know, small progress, but the disagreement is still very much there. So these groups, after the August session concluded, are still now sort of discussing and in conversations, and they are meant to conclude their discussions by mid-October. And then by that time, they will give their reports to the chair, like, you know, this is where we are on these issues. The chair will then take those reports. She will take the main takeaways and points of discussions that happened during August, and she will work on a second draft of her first draft, which she will then publish by the end of November. So that's where we are.
Gosh, that's a lot to unpack. And I'm glad that you did explain a little bit about what will happen between now and January, because I was wondering a little bit like how to keep things moving, given the sort of step backward that things took in August, how it will proceed forward in the interim. Perhaps just a quick follow-on question, Joyce, like, you know, there's been a sort of a handful of good summaries and analysis that have come out about the August session and some of the prior sessions as well. I think virtually all of them highlight scope and definitions as sort of one of these primary areas of divergence, you know, whether it's in how different criminal offenses are being defined and described, cybercrime itself, how it's being defined and described. Could you maybe tell us a little bit more about that, including why it's been such a polarizing debate?
Yeah, thank you for this very good question. And you know, there's a very long answer to this one, but I'll try to be brief. And this issue is really at the heart of this agreement between states at the AHC, the ad hoc committee. What is cybercrime and how it should be counted is one of those, as you said, polarizing debates that really stems from the different approaches that exist at the national level in terms of how cyberspace should be be governed, right? Between an approach that is very much, or like that favors increased state control, and one that is based on, you know, open societies. And that sort of clash of value, if you will, is very much present there and is at the heart of the disagreement in this process. And of course, there is strong human rights angle to this issue. We have seen in the last, I'd say maybe 10 years, countries that have an autocratic governance system, or countries that have a track record of controlling freedom of speech and other human rights, developing and enacting cybercrime laws that have been used to control online speech. So they use vague and loose terms with no safeguards, which means that they have quite a big leeway in terms of how these are implemented. And these laws we have seen in many countries being used to target minority groups, LGBTQI, human rights defenders, political dissidents, journalists, and others. And so by going after this sort of like content related you know, behaviors, these countries have expanded the definition of cybercrime, right? So you had instances where people were accused of cybercrime for taking a picture that, you know, the authorities did not like. You had instances where someone was put in jail because of a tweet criticizing, you know, the ruler, etc. So then you had quite a big, you know, definition of what cybercrime means. And so basically, when these sort of like same countries came to the HC and said, well, you know, in this UN convention, we would like cybercrime to mean this and this and that, this, of course, like, you know, raised a lot of alarm bells, because it's one thing to have that, you know, these approaches in national jurisdictions. It's another thing to have it in a UN treaty, which, you know, could be seen as legitimizing these approaches. And so, you know, throughout the HC process, and even before, to a certain extent, there has been the concerns around, you know, how would these states define cybercrime, particularly that the sort of the process, or the name of the process, the official name is not, you know, the process on cybercrime. It is the process on, you know, the criminal use of ICTs. So there has been a lot of tension and pushback against sort of like this approach, and you know, Western states and others calling for a narrow scope, you know, human rights organizations, the UN Human Rights Office, all of them sort of saying very, very important to keep this narrow to avoid, you know, sort of the abuse and jeopardize human rights. There's also another dimension to it. In addition to the content related offenses, a number of states have asked that to include a long list of traditional offenses like the distribution of narcotics, of drugs, arms trafficking, coercion to suicide, etc., to be included in that instrument on the basis that ICTs is helping exacerbate the problem. This also has been a controversial issue on the basis that, you know, if you include all of these crimes, where do you stop, right? Almost every crime nowadays has a digital component. So where do you draw the line? And also, if you kind of include those offenses in this UN convention, you know, most of these offenses are criminalized elsewhere. So you also risk this sort of like issue of contradiction and lack of harmonization between the different tools.
Thank you. That was a great answer. Very, very clear breakdown. Nina, I'm going to turn to you now and just, you know, ask if you have anything to add to what Joyce has described. And also, you know, in particular, because you have been representing and working with the African Union at the treaty negotiations, if you could tell us a little bit more about what has been the general attitude toward the treaty amongst African states? What are some of the priority issues or concerns?
Thank you so much, Alison, for this invitation to join this very important conversation. And thanks to the Washington Foreign Law Society, Stimson Center, and of course, the Harvard Carr Center on Human Rights Policy. And I'm glad to be doing this with Joyce. And I think Joyce has excellently captured what has been happening up to this point. I know there's hardly anything to add to what she said, but just to align to what she has said in terms of state participation, and of course, drawing it back to the attitude of African countries towards the treaty. we see with African countries that at the beginning, you know, the interest was not so much as it is now at the end. And I think this is also bringing some of the hurdles Joyce has talked about in terms of what states want to see in the convention, and states bringing in what their domestic approaches have been in their own national jurisdictions. And, you know, we're seeing this particularly with African countries. Now, international cooperation, for example, has been a challenge for African countries, a lack of prioritization of cybersecurity, reluctance of African countries to ratify the Regional Cybersecurity Convention. And so if you ask me, there are two key issues that have stood out for African countries, and I will talk about these issues and, of course, the concerns. The first one is international cooperation. I think Africa has come to a point that they've realized that, you know, with what we've seen recently, ransomware attacks, even at the African Union, that cooperation is very, very important. And although cooperation has taken different approaches, African countries are a bit concerned in terms of what principles would be used to guide the cooperation efforts. You know, if you go into the convention, there are large provisions in terms of international cooperation, trainings, mutual legal assistance, what this would mean for them, particularly in terms of sovereignty. The other concern is how they can express their specific needs. For example, if you look at the draft convention, it talks about the capacity of states to assist in terms of capacity building technical assistance. We've seen some African countries sort of concerned about what their needs will be, how their needs will be prioritized. And sometimes there's this sort of disparities where you want to answer, would it be financial assistance? What sort of sustainable assistance are we looking at? The other aspect is the methods and means the cooperation should be covered by the convention. Of course, this is not formal. The convention is not so prescriptive, but it will be good to see how this will be developed for countries like Africa that are usually at the end in terms of digital capacity and infrastructure. The other issue is capacity building, which I've touched upon. Particularly, it's impressive, you know, this is what African countries expressed when I talked with the African group, for example, that the statement of purpose particularly mentions developing countries. Whether this will be particularly good at the end of the day for the convention to say specifically for developing countries, for the benefit of developing countries, I mean, there is no hierarchy in terms of needs when we look at cyber criminal issues, but particularly because it mentions developing countries. Many African countries also wanted, specifically in alignment with Pakistan, that the statement of purpose should mention capacity building. I also had some issues with it, and I was sort of in support of USA and the EU saying it should be technical assistance, including capacity building, because then if we formalize capacity building in that sense, how would it be clarified? But just to go back to Joyce's point about understanding of definition of cybercrime, it's going to be a huge issue for Africa. Cyber-dependent, cyber-enabled. Every cybercrime legislation you pick in Africa, up to 90%, makes provisions for cyber-enabled rather than just cyber-dependent crimes. In fact, interestingly, Eswatini passed their cybercrime legislation last year, and it had provisions for genocide, crimes against humanity, through the use of computers. It criminalizes cyber terrorism, cyber stalking, which is very common, trafficking in humans. And we also saw a country proposing this at the 6th session in August. For example, in Nigeria, in 2020, the ECOWAS court ruled that Nigeria should abolish its cybercrime or amend its cybercrime legislation because of its Section 24, which sort of made provisions like insult and what have you. So you would find that African countries are a bit challenged if the convention would only rely on the strict understanding of cybercrime based on cyber-dependent crimes. And so many countries were rather proposing cyber-enabled and broad explanations, like Joyce had pointed out. The other issue for Africa will be diplomatic relations. We saw Russia start off by making proposition and saying it was speaking on behalf of certain African countries. And this sort of shows you the lack of cooperation dynamics that already exist in Africa in terms of cybersecurity. And of course, only 6 African countries have ratified the Budapest Convention, undermining that some of them wanted to use Budapest as a basis to say there should be no abstract or clear provision on human rights. However, only 6 countries had ratified. Only 15 countries out of the 55 African countries have ratified the Malabo Convention, which is the African Union Cybersecurity Convention. So it would be interesting to see if African countries would then ratify this convention when it comes into force, considering this sort of disparities. Again, the African Regional Cybersecurity Convention focuses on data protection and cybersecurity and not just cybercrime. Again, the position of the African Union towards the negotiations has not been as supportive as the EU and the CARICOM. The AU takes sort of an observatory position rather than speaking on behalf of African countries, and that has been another challenge. So you're not having that coordinated approach for African countries. The African group from the Vienna and the New York process, they've tried to do this, but again, you find that unlike the EU, where we have a harmonized approach, Africa is not same. Finally, the other challenge is sovereignty and what it will mean for data collection for African countries. Some of the countries have voiced this concern. Some others seem to be oblivious of what that will mean for them. And lastly, before I forget, human rights for African countries and what it has meant. And Joyce has already talked about this. I think the highest culprits in this regard have been African countries not respecting human rights in the internet and online space and using their cybercrime legislation to curtail and infringe human rights. There is so much of a history, and I worry that this convention will give them a leeway to even double on what has been existing and what they've been doing. Can you hear me?
Yeah, we may be having an issue with your microphone, Alison. Maybe.
Can you hear me, Michael?
I can hear you fine. Yes. Yes. Perhaps maybe you could log off and log back on, Alison. Maybe that could help out, because it doesn't seem like you're muted, but the mic is not working, in fact. So apologies for this, folks. Some technical issues, of course, when we're live, things like these happen. Why don't we maybe continue the conversation? Joyce, if you had any reactions to what Nena had just been discussing.
I hope I didn't take Alison's voice.
Alison to reconnect.
Yes, no, sure. Happy to do so. I mean, I think I was quite struck by what Nena mentioned about the role of regional organizations in, important negotiations such as this one, and to completely sort of agree and support that. We have seen, countries like that, CARICOM countries sort of speaking in a unified voice, which is not something that we've seen very much with African countries. And that sort of plays into the sort of bigger question of what role should international organizations play, not only in the negotiation of treaties such as this one, but also later on in the implementation, particularly for countries such as Africa, as you mentioned, Nena, who kind of, have particular needs and require a lot of sort of like capacity building and technical assistance to be able to implement the different obligations that will emanate from this convention.
One of the things I would have also said would have been resounding, of course, which seems to have just been more informalized, if I can put it that way, is the importance of accountability and sharing of best practices, particularly from the basis of regional organizations, because I think if you look at the approach from CARICOM, the approach from the EU, I think sitting beside them, I'm so envious, because I'm African. And I think it would be, as we go on with these conversations, it is not possible to formalize sharing of best practices, but it could be a pace setter, some sort of paradigm shifting approach. That could be a call for accountability, because it's easy to attend the negotiations. It's easy for the African countries to say what other African countries are saying. But I agree with you, Joyce, that when it comes to implementation, it may be a challenge, and no region will be left out in terms of implementing this convention. Countries may not ratify, but impliedly, we see that the way, for example, certain countries have not ratified the Convention on Civil and Political Rights, but it doesn't mean that the effect or there are no demands of accountability in their region. And that may happen with this as well, that even if countries don't ratify, with the nature of cyber crimes, they would impliedly be in a situation where they have to cooperate for issues like this. So we would see.
Well, since Alison is having technical difficulties, let me maybe take over some of the moderation here. And so I know we've been discussing with Nena the role of Africa in this conversation. Let me now turn to Joyce. One thing that we had discussed in previous conversations leading up to this panel was Chatham House's role in advocating for a gender-responsive treaty. Maybe discuss a little bit about what you would like, how the current draft stacks up to what gender experts and civil society is demanding in that respect.
Yeah, thank you, Micah, for that question. Yeah, very happy to speak on that topic. As you rightly said, Chatham House has been doing quite a lot of work on and advocating for gender mainstreaming the convention for very, very important reasons. First one being, doing so is important to understanding the whole picture. When we bring gender perspectives into the conversation about cybercrime, we get a much clearer and a more detailed, if you will, a view of what's happening in cyberspace. It's not just about the impact on women, it's about how cyber threats and cybercrime particularly affect people differently based on their gender identity and other aspects of their identity. So we wanted to make the point that, cybercrime doesn't hit everyone in the same way, and it can be especially, tough on minorities and marginalized groups, including women and non-binary people. For instance, online harassment or cyberbullying that can target people based on their gender. They lead to different kind of vulnerabilities and experiences. So, we've been advocating that it's very important for the cybercrime convention not to be a gender blind, because this will really result in a false sort of a picture of the nature and effects of cybercrime, and will create basically an obstacle for effective policy making. We are very strong on the views that gender blind policies risk, exacerbating pre-existing patterns of gender inequality and create new ones. So looking at the zero draft of the convention, throughout the process, we've been making the point, etc., and in the consolidated negotiating draft, which was basically the document that included all proposals in it, gender mainstreaming featured several times, which we were very pleased about. However, in the zero draft, this sort of like the prominence of gender mainstreaming, if you will, took a kind of like a step down. So there were mentions of gender mainstreaming, but they were placed in the preamble. And as you know, preamble is part of the convention. It sets the stage and provides context, but does not have the same legal weights as the articles themselves. So the worry is by keeping those references in the preamble is that it would basically not give gender equality the strong and enforceable commitment it deserves. And we've sort of published a commentary on the zero draft. Very happy to share with you in the chat. It's also online on the AHC website. But I guess in addition to sort of what was included in zero draft, something that we are quite concerned about was some of the discussions and the calls from different countries who were opposed to adding a gender perspective in the convention, particularly around the measures to prevent and combat cybercrime. So a very, very important issue. And, our hope is that, the sort of gender mainstreaming and its importance doesn't end up being like one of those sort of compromises that states make in order to reach consensus.
And to follow up on that, I think one of the things that this conversation highlights is the role that an organization like Chatham House, right, has in thinking about contributing to how this treaty is coming forward. Can you speak to that a little bit? So the role of non-state actors, civil society organizations, even tech companies, perhaps, in how the agreement is being drafted or is being revised, in addition to the state actors, obviously, who are the parties of the organization, of the treaty. And this obviously goes to both Joyce and Nena.
Yeah, sure. So the modalities of this process have been, much more favorable than other existing cyber processes when it comes to the multi-stakeholder involvement. So we as think tanks and, other civil society organizations and industry, etc., were all, sort of able to participate in the official sessions. I mean, of course, the time allocated for us to take the floor and speak is limited. And there's a lot of states who, are kind of like almost against the multi-stakeholder role on the basis that this is a state-led process, which is true. But it is also true that you cannot counter cybercrime just with states, right? This is a problem that very much involves the private sector, very much involves sort of civil society, human rights organizations, think tanks, and so on. So, it is almost like, absurd to think of a sort of a solution that does not have input from these different stakeholders. Now, in this process, as I said, there was opportunity to kind of intervene, take the floor, but also there were, in between each session, there were like the intersessionals that the Secretariat and the Chair organized, which were dedicated completely to the multi-stakeholders. And these were very useful too. And then we also had the opportunity to kind of submit our comments in writing. And I know from my personal experience that, a lot of states have found these, suggestions and analysis, etc., quite helpful in helping them navigate the complex issue of cybercrime and finding the right solutions.
Thank you, Joyce. And before I turn to Nena, let me just remind folks, please submit any questions you have in the Q&A. We have had a couple, so hold on to those questions, submit them, and we'll try to get to them at the end of the session. Nena, so turning back to you, so same question that we had for Joyce, and then in addition, one other perspective that I'd like you to elaborate on a little bit is building off of your role and experience at the Carr Center for Human Rights at Harvard. So we spoke about the gendered perspective in the convention. Let's now turn to the human rights perspective, maybe of the convention. How does a draft treaty think about, safeguard, enable, in fact, human rights, and what are some of the main fault lines in this debate?
Thank you so much, Michael. And I would say that Joyce as well has adequately sort of addressed that question. I think what I would just need to add is what is more worrying for me is the approach to the convention. Now, yes, we're supporting this multi-stakeholder approach, states, civil society organizations, tech companies. But then when you sit in the room during these negotiations, you would think that this cybercrime convention is about states being the victims rather than individuals. And I think that is what is more of a challenge for me. Now, when we draft criminal law legislation, is because we think that someone on the road could be a victim, someone in his house could be a victim. But then when you think of the approach of states to this convention, you would think that states are only the victims. And remember, the convention is focused on individual criminal responsibility rather than state criminal responsibility. And I think it's a very important question you've asked about the role of other multi-stakeholder groups. And I think the civil society organizations come with that understanding that people should be at the center of the negotiations. But I think states rather think that states are more at the center of the understanding. And of course, that then touches upon the value and the importance of human rights. And as well as Joyce has pointed out, the necessity for having human rights enshrined in this convention. Of course, states have voiced the concern that the convention is not about human rights. And so we shouldn't overflog it because it's not a human rights convention. But it's illogical to argue that you have a cybercrime legislation that does not underscore human rights. And another worry for me is the fact that there are just two articles that focus on human rights in the convention. The first is Article 5, and the second is Article 24. In fact, Article 25 could be a statement you could put in a preamble rather than an article that should be enforceable. If you look at the way the draft Article 5 is couched, it could pass as a preamble rather than an article that could be enforced. Again, talking about obligations under international human rights, one of the concerns I had was what of where states are not parties to certain conventions, like I've talked about before. And I think that Article 5 can be clarified, and thanks to countries like the EU that, sort of try to find clarification. Some African countries wanted it removed entirely. And like I said earlier, cited the fact that Budapest does not have similar provisions. But then apart from that, if you go to Article 24, you find that it sort of moves again from that sort of broad, ambiguous approach, which Article 5 has taken. The convention in terms of the conditions and safeguards are not very, very conceptually clear in relation to the provisions of the convention, not just for Article 6 to 16, but broadly in other powers that it tends to have given. For example, when you look at the draft convention and you look at the provisions of Article 24, it then generally allows states to go back to their domestic legislation and apply the convention on the basis of, you hear this resonance of what the domestic legislation allows. You found that some states were emphasizing the fact that it should be applicable or it should be in accordance with what exists in the domestic legislation. So there is that risk that the wording of the draft convention will rather create opportunities and make it easier for states to derogate from international human rights law and even infringe on human rights as it is. It could also mean that there are very weak checks, because then if you look at Article 24, there is no clear checks and balances in terms of the potential of states to overreach their powers. And an example of this, for example, is the draft Article 23, which is not specific and seemingly gives these broad powers to adopt such legislative and other measures as states may deem necessary to establish powers and procedures for the purpose of criminal investigation and proceedings. And if I can speak from the region where I'm from, it means that insult could also mean an issue in that instance without clarifying. And Joyce has also touched upon this. If you look at Article 23 as well, it means that if we interpret it the way it is, it's going to give more broad powers if you relate it to Article 29, 28, 27, and even Article 30. There are also purported broad powers of surveillance when you look at expedited preservation of stored data, expedited preservation and partial disclosure of traffic data, production order. These are actually good provisions when you think of human rights. But the question of what is clear, what will be safeguarding human rights, is what we need to see in the convention. Again, for issues like real-time interception of content data, my question was sitting there was, what is content in this instance? What would content then mean? Content could be anything. Again, human rights law allow for anonymization. Would that still be applicable in national jurisdictions? Will people still be allowed to anonymize their data and their information? And I say this because a general power to take steps necessary for cybercrime should never be a sufficient basis to infringe human rights. Now, you find that if you look at the draft convention, it talks about proportionality alone in Article 24. There were concerns that there should be legality, necessity, and proportionality. Some states favored proportionality, saying that proportionality was all-encompassing, but then allowing states to simply determine proportionality based on their situation. Anything could be proportional. If a state invokes national security, then curtailing freedom of speech online will be proportional in that instance. And so I would say that states must go back to international law standards, which provides conditions, basis to infringe human rights. It must be clear. Under law, it must be clear. The interference must be in pursuance of a legitimate aim. It must be in accordance with the law, and it must be necessary in a democratic society. And I think that whatever the wording of Article 24 is, whether proportional, legal, or necessary, it must be in accordance and it must be specific. And just to add to the point Joyce had said, I think what is even more worrying for me is some of the proposals, certain provisions that are being proposed by some states. For example, Article 15, incitement to subversive or armed activities, and it is directed to overthrow of a regime. Like I said, when you think about this convention and some of the proposals, you would think the state is just the victim and not individuals. So such provisions, for example, will leave you baffled, will leave you amused sometimes. There are also proposals for extremism-related offenses, calling for political ideology, social, and some of all those provisions that relate to threatening public safety, and this could mean anything in some jurisdictions. And so because of time, I'll just stop there, but I just want to say that it is also impressive to see the approach of states to child rights. When we talk of human rights, we only think, in this instance, freedom of speech online, freedom of expression, privacy rights. I was impressed to see that all states seem to be harmonized in an effort to protect children from child pornography. There were some amusing provisions, but you would see that they were all aimed at protecting children in terms of children not being able to give consent, grooming of children, preparatory acts, and even as Joy has talked about, at least a consent for women, gender, and vulnerable groups. It was interesting as well, the way states deliberated during the last session in relation to the draft convention. Thank you, Michael.
Let's try this again. Can you hear me now? Okay, great. First of all, I'm so sorry about that. I'm not really sure what happened. My Zoom just seemed to crash. I feel like whenever these things happen during some kind of a cyber event, there's always a temptation to make a joke about a cyber operation. Anyway, here we are. So I think we have just sort of one planned question yet before we'll get to a couple from the participants. But actually, this last question overlaps with one or two that were sent in advance. And this has to do with cooperation and coordination on the investigation of cyber crimes between states. I think that this was already touched on a little bit by both of you earlier in your remarks. Nena, if you wanted to speak a little bit more to this now, that would be great. Or Joyce, if you want to come in on this point as well.
Okay. I think the aim of the convention, I've talked about cooperation already, and it's obvious that from the language, from the terminology of the draft treaty, that it is aimed at cooperation, both regionally without saying it clearly, but more importantly, globally. And you would find this based on the provisions of mutual legal assistance, 247 response, exchange of information, technical assistance. But I think what is more worrying for me is the capacity to implement sort of those international cooperation provisions, the capability. We know that there is still this sort of digital imbalance in terms of capability, some states needing more than other states. I would say that it is important that as we get to the final session, that there should be more clarity in terms of safeguards, in terms of what the convention should criminalize in relation to international cooperation. If you look at the way the negotiations happened with Article 35, you will see that what international cooperation will mean is still not clear in terms of the convention. It was quite contentious, as well as particularly the questions about dual criminality, when states can decline and when states can accept in terms of dual criminality. And I think, but there is a basis to enhance international cooperation, particularly from demanding a more accountable approach or obligatory approach to dual criminality, so that states in certain regions, for example, in Africa, can then see this as a basis to where they are mandated to cooperate for international law, not just in terms of capacity building, technical assistance, but let cooperation also be a basis on what will be accountable, meaning what we find in the legislation, what states are drafting in their legislation, and, being mandated to protect for citizens and, even for the states. And just in terms of mutual legal assistance as well, I think it's also important that states are careful that mutual legal assistance will not then be overreaching and be a basis to infringe on sovereignty. I think I mentioned this before, but like I said, overall, yes, aimed at international cooperation, but then it's important that safeguards are put in place so that there will be accountability clearly, and importantly, implementation as well.
Yeah. If I may add to that, I agree with everything Nena said, and Nena, you made excellent points on the human rights issues within the zero draft and the discussions. I think when it comes to international cooperation, there are also quite a lot of concerns. So in the zero draft, the sort of approach that it was taken is that the exchange of evidence between states will be not just on the offenses that are covered in the treaty, but also for serious crimes. And that kind of has raised the question around what makes a serious crime. In the zero draft says, any offense that is criminalized for a minimum of 4 years. But we also know, as we have been talking, that some states will take one of those content offenses and consider them as serious crime and give them, even in some extreme cases, like life imprisonment. So there have been some concerns by states, including, for instance, like Canada, that have said, well, we think this is becoming a general mutual legal assistance treaty where states are the ones who decide, what a crime is and what a serious crime is, and it kind of opens up the door for measures that might be against sort of human rights. So there is also this kind of concern around, what will state cooperate on and what are the safeguards that exist. And the other point that Nana has already mentioned is around capacity. If you open it up, if you kind of give that broad sort of scope, will states be able to respond to all these requests that will come their way? That's a very big question.
Thank you. I think we're going to turn now to some of the questions that have been coming in from the audience. Nana, there's one for you in particular. During your tenure as vice chairperson of the AU-CSEG and your time working with the AU, this question is, how have concerns or did concerns about cybersecurity and data security practices amongst AU members shift or evolve following the 2018 and 2020 data breaches at the AU headquarters?
Thank you, and thanks to the person who asked the question, because this is very important. I wish there were member states actually listening to this. So the beginning of this year, there was this huge attack, and previously in 2018, there was also a suspected attack, which we believed came from a particular country, but it was reported. But then, first of all, the African Union did not make a statement saying, there's been this attack, and the approach to the attack, it was rather not thought of as the volume at which it should be. It was really disregarded as a technical issue, and this lasted for months. We also saw a repeat in Kenya where e-governance systems were shut down. We saw similar situations in other African countries this year, with a group known as Anonymous Sudan taking responsibility for this. We don't know. The group Nigeria as well said they foiled some of the attacks. Even during the election, Nigeria said, look, there were cyber attacks. Now, we've not seen, apart from the fact that the Malabo Convention has now entered into force this year, that is the difference we've seen, particularly the fact that more African countries now came up to ratify the Malabo Convention, understanding the need for cooperation. Now, the African Union also established the data policy framework because, like I said, our approach in Africa was to combine data security, data protection with cybersecurity, and states have really not accepted this. In response to the question as well, so many African states have drafted this legislation differently. And so there are questions of whether the Malabo Convention will be realistically implemented in those regions that already have their laws in place. Will it conform to the regional law, or will they continue to take the approach they've taken? Another dynamic in Africa is that you have sub-regional groups. So you have ECOWAS, you have SADC, EAC. These regions are also independently developing strategies in their regions. So it's not like much has changed, but what has happened this year is that there has been this rude reawakening of saying we need to prioritize cybersecurity, and we're seeing more African countries now showing an interest in the process, the UN process, but as well as now moving to say we need to ratify the convention. We saw 2 more African countries ratify Budapest, but what we need mostly is strategies. African countries lack strategies. The other thing being demanded from from the convention is a 247 network. And I think that would be a good basis if states ratify to have 247 networks in Africa, where you have said sometimes in Africa, computer emergency response teams are not generally working at the standard you will see in the global north. So it means it's been a challenge. You do not have cybersecurity authorities or agencies as you have in other places. But perhaps this is a call also to the African Union with the coming into force of maybe the UN treaty to see that things may be reorganized to hold African states to a point where they would understand that cybersecurity should be prioritized with the attacks that have happened.
Thank you. There's another question from a participant asking about, I like this question, it's kind of provocative. What are the chances of success of this convention, given the vast differences on issues such as human rights, cybercrime, and derogation from the convention for domestic reasons? And I think I would maybe add to that too. What are the chances of success of this convention, or how will it work practically with other relevant conventions, such as some of those that Nana has been describing within Africa, but also other regional or agreements. So yeah, given that we have a lot going on and that there is a disagreement in this process, where do you see things going forward? And this is a question for either panelist.
I mean, I think this is the $1 million question, and it's really hard to answer because I think all the options are on the table at the moment, right? As I said at the beginning, session 5, the hope was, states would agree to the compromise solutions that the chair put together, and then they would sort of discuss the remaining issues. Now that we kind of are back almost to sort of square one, it is hard to see, it's hard to have a certainty of the options that are there. So I mean, look, the modalities have stated that states should meet at least 6 times. So there is this big question: will the process be extended? That's an option. Will the second option, for example, states agree to kind of a skeleton, like the basics of the convention, and maybe the controversial issues such as extremism, terrorism can be addressed in protocols. There are also other options that are being sort of suggested outside of this process. So really, it's not very clear what the second or what the next steps will be. Also, it is worth noting that while this process will try and kind of aim for consensus, the modalities allow for 2/3 majority. So there might be a situation where, the chair will kind of put a revised draft, and then this draft could go to a vote. Now, what the sort of outcome from that will be is also quite difficult to say.
Alison,
did you want to add to that, Nana?
Yes. I was smiling all through when Joyce was responding, and I absolutely agree with Joyce. But I think for me, the big question is who will the convention be a problem for? Looking at, the arguments, the disparities, who in particular. So there are people who wanted this convention to come at the beginning and people who disputed. At the end of the day, perhaps, it's like the tables are turned. The people who wanted the convention may not be getting exactly what they wanted at the time they moved for the initiation of the convention. And one of the worries for me at the beginning was, I hope this will not be a replica of the Budapest Convention. If the Budapest Convention is already there, do we need this convention at this level? Would it be saying anything different? And I see that there is an effort to make sure that the convention is different from the Budapest Convention. And so you may see certain states wanting to push for certain provisions that would make it obvious that this is not particularly the Budapest. But if you ask me, I would also say that at the inception, certain countries just wanted a convention like the Budapest. If we're not parties to Budapest, let's have something at the global convention. But we've now come to a point where what we're seeing is actually bigger than what certain people anticipated as just a convention that will criminalize cybercrime. Now it is bigger. At the beginning as well, we believed that this convention will take into cognizance regional and other international frameworks. And that is something that, I've not seen. Of course, UNTOC has been repeated all the time, but then there are also other international conventions, and I think that is what is a challenge for so many regions. The fact that certain people, certain states keep emphasizing a particular convention, which is Budapest. Perhaps if other states were hearing, there are also other instruments in other jurisdictions that have never been mentioned. Perhaps it could have given that sort of encouraging involvement for states to be more aligned. I remember during the August session, one country took the floor and rebuked people for emphasizing the Budapest Convention all the time. But even though it's a good basis for lessons, and I think that has been sort of challenged. But I would say that a lot has been done. I believe that consensus will be reached. I think the ratification may not be as fast, but that does not take away, that is normal with international law treaties. There is usually no resounding at the beginning. So like I said, it's a question of who will it be a problem for and why would that be a problem? Is it more political than it is real? And I think we should distinguish from what will be a political understanding of the process as well as what we need. And it's about going back to understanding, why do we need a UN cybercrime treaty in the first place? What is the cybercrime legislation about? Is it about states wanting to witch hunt citizens, or because we want a safe cyberspace for everyone? And that is a question I want states to understand. Why did we start this process in the first place? What is the cybercrime legislation that tackles individual criminal responsibility all about? Who should be the subject and who should be the object of such a treaty? And I think that would help in terms of moving forward.
Absolutely. I think you've just gotten to the very foundational and fundamental questions that everybody had in their mind when this process began, and taking us back to that is very important indeed. I had intended to do kind of a last sort of lightning question about what this convention, this treaty could mean for accountability. I do feel like maybe you've kind of addressed that a little bit in some of your remarks just now, and I know that we're also about at time. But if you wanted to if you have anything to offer on that point at all, I'd be happy to hear it. Otherwise, maybe we can move to just closing up.
Yeah, I mean, very, very quickly on the accountability. I mean, this entire convention is about accountability, right? Like, it's about defining what cybercrime is. It's about creating a legal basis for holding perpetrators accountable for their actions. But I think, and of course, so that was the first kind of obvious dimension. The other dimensions is that, if this convention comes to fruition, that will of course help with cross-border cooperation, data sharing and evidence collection, building capacity, victim support, allowing states to apply the cyber norms and behavior, right? Because this is the dimension that we haven't had the chance to talk about yet. And also, if implemented properly in the sharing of information, in not allowing, for states not allowing their territories to be used for criminal acts, it will be states will be meeting their due diligence requirements, which is another kind of conversation and another process. So this convention, if done right, with the right safeguards, with the right scope, has a very huge and important potential. And it would be a real shame not to reach a kind of outcome at the end of this process, because so much effort and resources have been invested into it.
Go ahead, Nana.
Yeah, absolutely. I totally agree with Joyce. It would be a shame if after all of this, but I am very optimistic. And I just wanted to say that, this process as well, thinking about states' approach in terms of who the subject is, who the object is, in terms of accountability, I agree with Joyce that this is, if done appropriately, if finessed in the right approach, this would be a very important document, particularly if you look at the provisions for 247 points of contact, mutual legal assistance. I think it would be a good basis, Article 35 and 40, to even push for accountability. But I think I would also ask another question. I'm very good at asking questions here, is who are we expecting accountability from? Remember, this convention is focused on individual criminal responsibility for cybercrime. In this instance, we need to understand accountability for states. And it just got me thinking about the Rome Statute. The Rome Statute, which is the treaty of the International Criminal Court, even though it's a treaty that is aimed at individual criminal responsibility, we have seen in one way or the other that treaty being used to hold state actors accountable for such huge criminal activities. So it's not just focused on individuals who are just normally, you know, everyday like me, but then you've seen state actors who in their individual capacity being held liable. And I see that this convention, perhaps that is what states are thinking. And so if we're clear in terms of accountability in this regard, then states may sort of feel satisfied that they have also been prioritized, because that is why there is all this push for liability for some certain offenses that are not necessarily just cyber dependent. But just to add to what Joyce has said, apart from what we want to define, I think if we're also clear on dual criminality, it would also be a good basis to ensure accountability with the convention.
Fantastic responses. Nana, I love your questions. I also love all of your responses and your thoughts. And Joyce, thanks to you as well. I feel like we've been very lucky to have both of you with us today to walk us through what's happened, unpack some of the nuances and the technical detail. It's challenging to follow these processes, you know, if you're not there day to day and kind of in the nitty gritty of it. And I think you've both done a really wonderful job of elevating and lifting up, you know, what are the main points of contention? Where is there also agreement and hope? What have been some of the good things that have been developed through this process? And, you know, what we might expect going forward. So thanks to both of you very, very much. To our audience, I'm sorry if we didn't get to all of your questions today. Please feel free to follow up with me over email, and I can certainly connect you with our panelists if that would be of interest to you. And just a thanks to my colleagues, Deborah and Catherine, for your support on this event. Michael, thanks to you and to the Washington Foreign Law Society and all of our co-sponsors as well.
Thank you very much.
Thank you, Alison, for moderating the session.
Thank you.
Thank you so much. Bye. Have a good evening. Thank you.
Thank you all.